Perfect. And then two questions, I think, for me.
Yeah, perfect. All right, great. So the first question, let me open it up. Both quite nice questions. So the first one is, and this, if I was you, Nick, maybe give us different examples where, for example, it's not a pool. But in this particular property, a person rented a property that had a pool in it. The pool was leaking when they moved in. There were promises by the owner to fix it. I don't know if these were in writing or implied, not 100% sure. But the tenants did complain and had to keep filling up the pool, obviously, through utilizing it. They even installed a pool cover to limit evaporation. And eventually the property was sold to another buyer. So this is a plot twist now. So we actually have this question that could be answered simply on these facts alone. Bear in mind, and now there's another buyer that steps into the shoes of the landlord and who has to fix the pool as well. Is the tenant entitled to claim these damages, whatever they paid for it, the cost of filling up the water? Are they entitled to claim this, number one? And from whom can they claim it?
Perfect. So let's just deal with a couple of principles, firstly, in relation to letting of a property. So when a tenant is in occupation of a property, they obviously have an obligation to maintain that property, okay, in a good condition. So they do have an obligation to maintain things to make sure that they aren't destroyed. And this is often a tricky question when it comes to pools, because pools are something that if they aren't, for instance, continually kept full, they can deteriorate very quickly and very badly in the circumstances. So there was an obligation on the tenants here to maintain. But that being said, if you are a landlord and you are leasing a property to a tenant, you must remember that as the landlord, your obligation is to provide use and enjoyment of that particular premises. Your obligation is to provide the property in a useful form, or if there is something that perhaps isn't part of the property that is intended to be used and enjoyed by that tenant, you should at least have that acknowledged between the parties that this is something that does not form part of the lease agreement. And then there should be a equatable rental deduction or consideration which is taken into account. So to give you an example, say you're as a landlord, you lease out a property, there is a storage unit or a little flatlet on the property, but the lease is under the understanding that that particular area or storage unit or whatever the case is not actually part of this rental. That should be clearly defined in the agreement between the parties, preferably in writing, okay? And there should be obviously a consideration or an agreement for how much rental that's going to be, taking into consideration that a portion of this property is not actually going to be for the use and enjoyment of the particular tenant in the circumstances. So these are the obligations that the parties must play with in the circumstances. So in this particular question, look, there's going to be a play between these two things. The tenant had an obligation to make sure that the pool didn't deteriorate and take damage, but the landlord has an obligation not to provide things that are broken in the circumstances. What's interesting for this particular question is there is the submission that the owner made a promise to fix the pool in the circumstances. So there seems to be an acknowledgement on behalf of the erstwhile landlord, so previous landlord, that there was a problem and that they were going to take steps in the circumstances to actually remedy the problem. And so in respect to this particular question, I mean, the property is now sold, it's owned by a new owner. If the tenant had the ability to claim, does the tenant have the ability to claim the damages that they've suffered in water paid against the new owner? I'm not sure 100% on that. But where I do think the tenant has perhaps a claim in this particular circumstance is there is an undertaking which has been given by the previous owner in respect of this particular property. So there was a recognition that there's a problem. the owner assumed responsibility and indicated that he was going to take steps to remedy the circumstance. And if that previous owner did not take those steps per the agreement that he was going to do, and as a result, the tenants continually had to pay more and more water. So they've suffered a damage of a kind. There is, in my view, a claim which may exist there, not even in terms of the lease agreement itself. This could be a completely different, another contractual claim, which exists between those two people. So it's like any other agreement that we do and we have within our law. Someone agreed to do something, they didn't do that particular thing, and as a result, if you can show a quantified damage which you've suffered in the circumstances, you might be able to claim that in the circumstances. So the question is the tenants entitled to claim back the cost of water upon moving out? They don't say against who, but I think in terms of the facts that we've got here, the tenant may very well have a claim in respect of damages against the previous owner who, despite undertaking to fix the problem to stop those damages from accruing, did not do so.
So out of interest, Nick, just to kind of like make your life difficult, because in my mind, it is a challenging question. If you have a lease and you anticipated that it would include the pool, and the pool would come in a certain condition, didn't come in that condition, arguably it's defective, so it's possible that certain damages do arise by virtue of the lease itself, right? And on top of which the previous landlord actually agreed to repair, which could also be an acknowledgement of a duty in terms of the lease. Huurgradverkoop, which is the passing of the delegating, well, essentially assignment of rights and duties from one landlord to a new landlord who happens to buy the property, and entitling the tenant to recourse or enforcement against said new landlord. What would you think that there's a possibility, even an inkling of a possibility on that narrative, that the new landlord could actually land up in trouble with that? Because that's interesting as a property owner. You buy a property, you have a tenant, and now all of a sudden this tenant's suing you because the previous guy never repaired the pool.
So when we're dealing with huurgradverkoop, we must just remember for our listeners that this is a ex lege, so an operation of law principle, that when a purchaser buys a property, the lease agreement survives that purchase. So a new owner of a property, if their property is being leased out, steps into the shoes of the landlord and has all obligations and rights in terms of that lease. So they must continue to lease the property to the tenant under the conditions that have been agreed to with the previous landlord, and they are entitled to receive rental under that particular lease agreement. So it's a good question, Bruno, because as far as I'm concerned, if the obligation existed on the previous landlord to remedy this issue in terms of the lease agreement, so it's really a question of, was the leaking pool affecting the tenant's use and enjoyment of the property in the circumstances? Because if the answer to that is yes, then there's an obligation on the tenant that steps into the shoes of the previous owner to remedy that situation. In this particular circumstance, I really think it's a question of, well, we've been told that there's a leaking pool, and obviously they've had to continually fill up the pool in order to keep the pool, they said, up to the weir. So yeah, from further damage occurring. The question then is, well, did that diminish the use and enjoyment of the tenant's use and enjoyment of that particular property? And unfortunately, I think that is a question of facts on the particular circumstances that we'd have to look into deeper. So potentially, but it would, as we often say in the PLA, it really depends on the facts.
Yeah, no, fair enough.
Yeah.
Awesome. Thanks so much, Nick. And that 100%. Is it.
Perfect.
Awesome. Have a great one. See you next week.
Too.